And in reverse order, starting with you, Bentley, I'd like each one of you to give what you think are the most important key takeaways that practitioners should leave today's webinar with and keep top of mind as they return to their practice. Bentley, let's start with you.
I think certainly the key takeaway is that patentees in Canada can rest assured that the courts are providing more guidance with respect to patent validity. That should bring the cost of litigation down and should result in more success at trial for patentees. Thank you.
Greg Spearer.
Sure. I think the key takeaway from my perspective, I think all three of us have mentioned the extraordinary cost of IP litigation and trying to be proactive in trying to protect your intellectual property, again, on a global scale. I don't think there's a silver bullet to IP protection, but I think there are different strategies you should consider, and I think you need to consider it not just in your particular jurisdiction, whether it's the U.S., whether it's Canada, whether it's the U.K. I think you need to look at it on a global scale, because if you're if you have to recapture your IP, you're losing sales and you're spending money on folks like the three of us on the phone as opposed to making money. And I think that's something all practitioners need to be considerate of.
John McEwen, you get the last word.
Well, I summarized the things that are happening in primarily the federal and appellate courts and on slide 36. And if you're going to be asserting your rights, you're going to have to take those matters into consideration. And obviously best to make sure you get the protections, because that can make your job easier in terms of enforcing them. And then you have to look at it critically and carefully to make an assessment of the best way to go. And that's basically it.